Hello, and welcome. Today, we're going to dive into a powerful legal tool, declaratory relief. Specifically, we'll be exploring Rule 63 of the Rules of Court, which governs this remedy. By the end of this session, you will be able to: first, identify who can file a petition for declaratory relief. Second, understand the essential parties involved. Third, know the critical notice requirements. And fourth, grasp the court's discretion and the possibility of converting the action. So what is declaratory relief? It's a special civil action where a person asks the court to declare their rights, duties, or legal relations under a deed, will, contract, or other written instrument, or under a statute, executive order, or regulation. The key here is that there's no actual breach or violation yet. The purpose is to prevent a future controversy, or to resolve an existing uncertainty. Think of it as asking the court for a legal opinion on a specific situation before things go wrong. It's a proactive measure, not a reactive one. Let's start with the first objective: who can file a petition for declaratory relief? Rule 63, Section 1, specifies the parties who may file this action. The rule states that any person interested under a deed, will, contract, or other written instrument, or whose rights are affected by a statute, executive order, or regulation, may bring an action for the purpose of determining any question of construction or validity arising under the instrument or statute, and for a declaration of his rights or duties thereunder. Let's break that down. First, the petitioner must be a person interested, civil. This means they must have a legal interest in the subject matter, not just a general curiosity. Second, the subject matter must be a written instrument or a law. This is a crucial limitation. You cannot seek declaratory relief for a purely oral agreement or a general legal principle. Third, the purpose is to determine a question of construction or validity. This means you're asking the court to interpret the meaning of a document or law, or to rule on whether it's legally valid. And fourth, the ultimate goal is a declaration of rights or duties. You want the court to clarify what your legal position is. A key requirement, a ripeness requirement, is that there must be an actual, justiciable controversy. This means there must be a real conflict of interest between the parties, not just a hypothetical one. The controversy must be ripe for judicial determination. So, to recap, the petitioner must be an interested person, the subject must be a written instrument or law, the purpose must be to construe or validate, and there must be a ripe controversy. Now let's move on to our second objective: understanding the essential parties involved in a declaratory relief action. Rule 63, Section 2, dictates who must be made a party. The rule states that all persons who have or claim any interest which would be affected by the declaration shall be made parties to the action. This is a mandatory requirement. The court cannot issue a valid declaration if all the necessary parties are not present. This is to ensure that everyone whose rights might be affected has a chance to be heard. So the general rule is: include everyone who has an interest that could be affected by the court's decision. Let's consider a practical scenario. Imagine a dispute over the interpretation of a will. The will states that a certain property is to be divided among the children of my sister Maria. If Maria has 2 biological children and 1 adopted child, and there's a question about whether the adopted child is included in the term children who should be parties to a declaratory relief action, the petitioner would be one of the children seeking clarification. The respondents must include all other children, both biological and adopted, because their share of the inheritance would be directly affected by the court's interpretation. Failing to include a necessary party is a fatal defect. The court will either dismiss the case or order the petitioner to amend the petition to include the missing parties. This is a common pitfall, so always be thorough in identifying all interested parties. Next, let's tackle the crucial notice requirements, which are often tested in the bar exam. Rule 63, Section 3, outlines the specific notice that must be given to the Solicitor General and, in some cases, to local government attorneys. The rule states that in any action which involves the validity of a statute, executive order, or regulation, or any ordinance or other governmental regulation, the Solicitor General shall be notified by the party attacking the same, and shall be entitled to be heard upon such question. This means if your petition challenges the legality of a law or government issuance, you must notify the Solicitor General. The Solicitor General is the principal law officer and legal advisor of the government of the Republic of the Philippines, and they have a right to defend the validity of government acts. So, if you're questioning a statute, executive order, or regulation, you must notify the Solicitor General. But there's more. The rule continues. If the ordinance or governmental regulation is alleged to be unconstitutional, the provincial or city attorney or attorney general, as the case may be, shall also be notified and entitled to be heard. This means if you're challenging a local ordinance or regulation on constitutional grounds, you must also notify the local government attorney. This ensures the local government can defend its own laws. A common bar exam question might involve a petition challenging a city ordinance. The correct answer would be that both the Solicitor General and the city attorney must be notified. Remember this dual notice requirement. Failing to give the required notice is a jurisdictional defect. The court cannot proceed with the case without it. It's a mandatory requirement that protects the government's right to be heard. Let's now discuss the court's discretion in declaring rights and the possibility of converting the action. Rule 63, Section 5, grants the court significant discretion. The rule states, the court may refuse to exercise the power to declare rights and to construe instruments in any case where a declaratory judgment or decree would not terminate the uncertainty or controversy which gave rise to the action, or in any case where the declaration or construction is not necessary and proper at the time under all the circumstances. This means the court is not obligated to grant declaratory relief. It has the power to refuse if it believes the declaration would be useless or unnecessary. The two main reasons for refusal are, first, if the declaration won't end the controversy, and second, if it's not necessary or proper at that time. A common scenario for refusal is when there has already been a breach of the instrument or law. If a contract has already been violated, the proper remedy is an action for breach of contract, not declaratory relief. The court will likely convert the action. This brings us to the concept of conversion. The rule states, if, before the final termination of the case, a breach or violation of an instrument or a statute, executive order or regulation should take place, the action may thereupon be converted into an ordinary action, and the parties shall be allowed to file such pleadings as may be necessary or proper. This is a very practical provision. It prevents the petitioner from having to file a new lawsuit from scratch. If the situation escalates from an uncertainty to a full-blown breach, the court can simply convert the case into a regular civil action for damages or specific performance. So remember, declaratory relief is for preventing a breach. If a breach occurs, the court has the discretion to convert the case into an ordinary action. Let's now look at some practical scenarios where declaratory relief is commonly used. These examples will help solidify your understanding of when and how this rule applies. First, a very common use is to interpret the terms of a contract. For instance, a tenant might file a petition to clarify a clause in their lease agreement, such as whether they are responsible for a specific type of repair. This is a perfect fit for declaratory relief, because there's an uncertainty about the contract's meaning, but no actual breach has occurred yet. The tenant just wants to know their obligation. Second, it's often used to determine the validity of a statute or ordinance. A business owner might challenge a newly enacted city ordinance that they believe is unconstitutional or beyond the city's powers. Here, the business owner isn't violating the ordinance yet. They are proactively asking the court to declare it invalid to avoid future penalties. Remember, in this case, the Solicitor General and the city attorney must be notified. Third, it can be used to clarify property rights. For example, two neighbors might have a dispute over the exact boundary line between their properties, or the interpretation of an easement. A declaratory relief action can resolve this uncertainty by having the court declare the correct boundary or the scope of the easement, preventing a more serious dispute later on. Fourth, it's used to determine the status of a person. For instance, a person might file a petition to declare their Philippine citizenship or to establish their status as a legal heir. This is a declaration of a legal status, which is a type of right or legal relation that can be clarified through this action. These examples show the versatility of declaratory relief as a tool for resolving legal uncertainties before they escalate into full-blown conflicts. While powerful, declaratory relief actions are not without their challenges. Let's discuss some common legal issues that arise. Understanding these issues will help you avoid pitfalls and argue your case more effectively. The most frequent issue is the ripeness requirement. As we discussed, there must be an actual justiciable controversy. The court will dismiss a case if it's merely a hypothetical question or an advisory opinion. For example, you can't ask the court to declare what would happen if you were to violate a law. You must have a real, existing uncertainty that affects your rights. Another common issue is the breach requirement. Declaratory relief is not the proper remedy if there has already been a breach or violation of the instrument or law. In such a case, the action should be for specific performance, damages, or injunction. The court will look at the facts to determine if a breach has occurred. If it has, the court may convert the action, but it's better to file the correct action from the start. A third issue is the necessary parties requirement. As we saw, all persons who have an interest that would be affected by the declaration must be made parties. Failing to do so is a jurisdictional defect. This requires careful analysis to identify everyone who might be impacted by the court's decision. It's always safer to include more parties than to miss one. Finally, the notice requirement is a frequent source of error. Forgetting to notify the Solicitor General or the local government attorney when challenging a law is a fatal mistake that will lead to dismissal. Always double-check if your case involves a statute, executive order, regulation, or ordinance, and if so, ensure the proper government attorneys are notified. By being aware of these common issues, you can better prepare your case and avoid procedural pitfalls. Let's now discuss the appropriate remedies available in a declaratory relief action. The remedies are directly tied to the purpose of the action. The primary remedy is, as the name suggests, a declaration. The court issues a judgment that declares the rights, duties, or legal relations of the parties. This declaration is legally binding and serves to clarify the legal position of the parties, preventing future disputes. For example, if the court declares that a certain clause in a contract is void, that declaration is the remedy. It doesn't order anyone to do anything. It simply states the legal truth. However, the court can also grant further relief. Rule 63, Section 6 states, "Further relief based on a declaratory judgment or decree may be granted whenever necessary or proper." This means that after the court has issued its declaration, a party can file a separate petition in the same case to ask for additional remedies that flow from that declaration. For instance, if the court declares that a tenant is not responsible for a certain repair, the tenant could then file a petition for further relief to recover the money they already spent on that repair. It's important to note that the further relief must be based on the declaratory judgment. You can't ask for something completely unrelated. It must be a logical consequence of the court's declaration. So the remedies are a declaration of rights, and potentially further relief based on that declaration. The key is that the action is primarily about clarifying legal positions, not about enforcing them. To help you retain the important sections of Rule 63, here are a couple of memory aids. These can be very useful for the bar exam. First, let's remember the key sections. Section 1, Who may file, Section 2, Parties, Section 3, Notice, and Section 5, Discretion, Conversion. You can use the acronym WPNDC. W for who, P for parties, N for notice, D for discretion, and C for conversion. This helps you recall the order and content of the most important provisions. Second, let's remember the two main reasons for the court to refuse declaratory relief, found in Section 5. The court will refuse if the declaration won't terminate the controversy, or if it's not necessary or proper. You can remember this as no TNP, no termination, not necessary or proper. Finally, for bar exam tips, always remember the two most common pitfalls, the breach requirement and the notice requirement. If a question describes a situation where a breach has already occurred, the answer is likely that declaratory relief is not the proper remedy. And if a question involves challenging a law, always check if the Solicitor General and local government attorney were notified. These are classic bar exam traps. Let's quickly recap what we've learned today. We started by defining declaratory relief as a proactive action to resolve legal uncertainties before a breach occurs. We covered the key provisions of Rule 63, who can file, the mandatory inclusion of all interested parties, the critical notice requirements for challenging laws, and the court's discretion to refuse or convert the action. We saw practical scenarios like contract interpretation and challenging ordinances, and discussed common issues like ripeness and breach. Finally, we learn that the primary remedy is a declaration, with the possibility of further relief. You are now equipped to identify who may file a petition, understand the essential parties, know the notice requirements, and grasp the court's discretion and conversion. You also have practical scenarios, common issues, and memory aids to help you master this topic. Thank you for joining me. I hope this has been a helpful and clear explanation of Rule 63 on declaratory relief.